David Mead, welcome to us from the University of East Anglia. Delighted you could be here with us. And so, yeah, over to you, David, because time is short.
Yes, I'll try and be brief. And thanks very much for the invitation. Thanks everyone for coming along. It's been really interesting to hear what people have been saying. I know there's a mix of lawyers and non-lawyers, so I'll try and pitch it down the middle. But I'm not a Labour lawyer, I'm a human rights lawyer. So there is going to be some, and I know there are a good couple of Labour lawyers on here. So I know Diamond has gone, who will probably correct me on stuff. The first thing I wanted to say really is about the union and what the union has been doing and its seemingly total intransigence on the matter. And I've just scribbled on a piece of paper, you know, how worse off can we be if it decides to bring it? I mean, if it brings an action and we lose, all that's happened is we've confirmed the position that we're working to now. I mean, there is a risk that a court judgment becomes even more expansive. But I mean, it seems to me that we're all probably not working or working under the assumption that we are or not going to have pay deducted, and clarity on that led by the union just seems to me absolutely critical. And I can't see what the downside is of not at least bringing a case. And if anyone, I've put it in the chat that I was due to have been a test case years and years ago and was just so badly let down that I pulled out, and they've never brought anything. I've got emails saying we're going to be lodging papers in the next couple of weeks. That was 7 years ago. Nothing has happened. You know, they've behaved. I know Sean's on here, but others, they have behaved disgracefully over this. I'm quite happy for that to be recorded. So I will just say a few things about sort of some of the human rights approaches that I've put in that I developed in the blog. And again, apologies to the sort of non-lawyers, non-human rights lawyers. I think there are two. None of these are certain, but I think they are all at least arguable, and some possibly quite strongly arguable, such that you could at least get into court and see what a court could make of it. So I think there are two possible human rights routes, one certainly actually for QM and a few of the others on the call, which I didn't really develop in the blog, and I've been doing a bit of thinking about today, not particularly successfully, which is that if you have your possessions taken away from you, and that is disproportionately done, you have open to you a claim under one of the aspects of the convention. So for the human rights lawyers, that's A1P1, peaceful enjoyment of your possessions. I think the issue there is that a salary counts as your possession, and that's what I was trying to investigate today, not particularly successfully. But the disproportionality there would be, you've already lost your salary once, you're losing it twice for the same thing. It's a double penalty, and I just can't see how that wouldn't be disproportionate if not getting your salary counts as a possession. So that's one possible human rights route, but to be explored. The other where I've done a bit more exploring is that this would be a disproportionate interference with people's rights to associate under Article 11. I take the various points, Lizzie, and I think Diamond from earlier about the right to strike and how that this is not as clear as it could be in domestic law or at European law. I'm not entirely sure. I don't think you would need to have it as an individual right. I think the union, or you could claim that it's rendering the union's activities less effective if people are not able to go out on strike. You know, if I at QM are not going to go because I'm going to be deducted, my at UEA rights suffer because the collective strength is much less. So I think there is certainly an argument at a human rights level that this becomes an interference with the right for a trade union to associate, and implicit in that is the right to bargain collectively, and quite possibly implicit in that is the right to withdraw your labour in order to force that collective bargain through, or at least to force an employer into negotiations. So say none of this is clear cut, but I think it is at least arguable that there is an Article 11 interference. And then the next thing, which is what I develop in the blog, is how might you get those before a court? And again, apologies to the non-lawyers, I'll try and keep it as non-legally as I can. So the Human Rights Act allows people to bring direct claims against a public authority. So this is outside of employment law, how we can challenge government decisions as being breach of our human rights. So one possible route would be that a university counts as being a public authority within the meaning of the Human Rights Act. And if that is so, then you would have a direct claim against your university employer for breach of your Article 11 rights. For the human rights lawyers, so for Meris in particular, I mean, obviously there are issues there about core and hybrid, which you may have read in the blog, I don't know, and whether or not it's a private act and a public act, which you'd have to explore. But I don't think it is clear cut that a university employment decisions would not be covered by the Section 6 duty. So I think there is certainly a case to be made there that a university, as a university employer, has direct duties to you not to restrict your rights to strike and restrict your rights to, thanks Meris, haven't seen it, I'll look it up, to restrict your right to strike and the union's right to collectively, to bargain collectively. If that didn't work, then the other route is arguing that the court is required to effectively revisit those contractual terms that Diamond was talking about earlier. So revisit the contractual position on deductions for pay, deductions for ASOS, 100% deduction for ASOS being perfectly lawful. So those are the cases, sorry, for the employment laws of Vilajinsky and Miles, for example. And the argument that you would be mounting there is that the court, in order to protect my human rights under Article 11, has to revisit those contractual rules. And the most obvious route, and there's no case law on this, but there is certainly some academic thinking on this, that this would be to rewrite the implied term of what's called mutual trust and confidence that Diamond was talking about earlier, and effectively say there is a duty, an implied duty on employers not to act in a way that breaches people's rights. Because if you do so, or not to act in a way that breaches someone's rights disproportionately, because if you do so, you are not treating your employees with the mutual trust, respect, and confidence that they should require of you as an employer, as well as an employer requiring it of me as an employee. And if that were so, then again it becomes an implied term of the contract that reasonable employers don't disproportionately restrict their employees' human rights. Reasonable employers, therefore, don't disproportionately restrict the rights of their employees to strike or to take collective action in pursuance of collective grievances. And if someone does so, so if an employer does disproportionately interfere with that by deducting far more of your salary than is warranted by the number of hours you've lost. So in my own case at UEA, we were penalised a whole day for taking a 2-hour strike. So we worked for 5 of the 7 hours, but we lost a full 7 hours pay. Or at QM's case, for example, double deductions for not rescheduling work that you've already lost for. Those would, I think an employer would really struggle to argue that those are proportionate responses, given the need to balance our important right to strike and a university's right to educate its students. That's not to say that we shouldn't suffer any deduction. And taking the point, apologies, I think it was James's point from earlier on, or it might have been apologies from Birmingham. Nobody is saying that we would probably not lose any money for action short of a strike, but it would have to be commensurate with the loss. And as I put in the blog, the one advantage perhaps that we now have of workload allocations is that a university cannot say, oh, it would have taken you 4 days to mark one exam paper. We're going to duck you 80 times 4 days because there were 80 papers, when you have in front of you a model that says I'm only entitled, you're entitled. So my university expects me to mark 3 an hour, 20 a minute. So if I haven't marked 5, I'm deducted, not quite 2 hours worth of pay. So I think there would certainly be some very strong cases to be made. So no, by no means clear cut, by no means certain, but at least arguable. I'll finish that. I won't. The other part of the blog was about detriment, but that's not really so much a human rights issue. So I'll leave that aside, but partly because we're waiting the Court of Appeal decision in Mercer, which actually may totally stymie my argument. So I'll leave it on those two.
Thanks so much, David.